Warm good afternoon to one and all present here. I, Dr. Leeru Mittal, Head of the Department, School of Law, Lovely Professional University, would like to extend heartiest welcome, ma'am. Thank you. So, today we have with us Professor Dr. Jaimala, Professor, University Institute of Legal Studies. Ma'am has an enriched academic qualification. She has done her PhD in Law from HPU Shimla. She has pursued her Masters from HPU Shimla, LLB, that too from HPU Shimla. Ma'am has done BSc Medical, that again from HPU Shimla. And now coming to the key expert areas of ma'am, she has been handling with the courses related to family law, child rights, women rights, labor law, law, health and technology. Ma'am has an enriched teaching experience of 17 years with 4 edited books, 10 chapters in edited books, 29 papers published in different various reputed journals. She has delivered more than 17 lectures and has chaired as a resource person more than 17 international and national conferences and has 45 paper presentations. On behalf of School of Law, Lovely Professional University, ma'am, we extend our warm welcome and greetings. Now over to you, ma'am. Thank you.
We begin?
Yes. Start your presentation.
Best of luck.
Thank you. Good afternoon.
Very good afternoon.
Good afternoon to the other people here and other people online as well. My name is Advocate Adish Halarnkar. I come from the small state of Goa. The topic.
You're from Goa?
Yes.
Okay.
So my topic is Maintenance and Welfare of Parents and Senior Citizens Act 2007, a socio-legal study with special reference to the state of Goa. Now, this topic is very close to my heart because firstly, when I was practicing or when I started my independent practice in the year 2019, this was the first case which came to me. A gentleman, maybe around 72 to 73 years old, came to me and he started inquiring. He told me that his son had, in a very good manner, asked him and his mother, so the wife of the gentleman, to execute a gift deed. We know that as parents, we would do anything for our children, so he did that. He executed a gift deed in favor of the child. Now, what is a gift deed? Is usually out of love and affection. That's how it says. That's what's the difference between a sale deed and a gift deed, rather. So he executed the gift deed. Initially, the son used to look after them, and suddenly the son stopped looking after them. Around 8 years thereafter, the gift deed was somewhere around 2003 or 4, and 8 years thereafter, he started being beaten up by the son as well. So he did not know what to do. His wife was very emotional, so she did not want to do anything as well. Now the statutory time limit to challenge a gift deed under the Contract Act was also void. Section 3 limitation was 3 years old, and he could not. So he came to me in 2019 and he asked me what option did he have. I evaluated the laws, and for the first time I came to know, I being an advocate was ignorant of this act. So I came to know that there is section 23. Now section 23, let me call this act MWPSC Act or the act hereinafter just for the sake of brevity. So section 23 of the act made me know that a gift deed or a transfer deed can be cancelled, and the authority will presume that the deed is null and void, fraudulent, etc. if the transferor, that is a senior citizen, gives the property to the transferee and thereafter the transferee fails to maintain him, provided this was on a condition, the gift deed was executed on a condition that he would maintain. So now if the panel recollects, my thing was the gift deed was on love and affection, so there was no condition. So secondly, what I observed was this gift deed was in the year 2003-2004. The act came into play in 2007. So whether this gift deed could be challenged under this particular act as well, whether the provision is retrospective. So all these questions came into my mind, and this finally came to the study. Sooner I came to know that the gentleman has also expired. He did not get any fruits out of anything thereafter. The property still remains with his son, and nothing could have been done. Now, a brief introduction to the scenario in India. Now, 2011 census states that there are 10.38 crore senior citizens in India. which is expected to reach 17.32 crores in 2026. Now, Agewell Foundation states that 2/3 of 10.38 crore were going through financial crisis and 4/5 depended on their family for money. Now in Goa, there's a projected population in 2024 was 15.85 lakhs and it is anticipated to reach 16.65 lakhs by the year 2036. Now the population of senior citizens is 1.89 lakhs out of it. So it is 11.4% approximate. Whereas in the rest of India it is 7%. So we know that the population of senior citizens in the state of Goa is more as compared to the rest of India. There was a study conducted in 2023 by All Goa Senior Citizens Federation in collaboration with Helpage India and Directorate of Proveedoria. This word might sound a little bit different. It's the Institute of Public Assistance. We in Goa are influenced with the Portuguese law, so we still have a tendency to name our departments under the Portuguese names. So that is why it is named as Proveedoria. So what was observed that 70% experienced emotional and psychological abuse, 65% were subjected to financial exploitation, 55% experienced physical abuse, and 5% stated that they faced neglect. Now, what research gap? I went through a lot of literature, and what research gap did I find was that the available literature on the topic, it was deficient with respect to extensive studies in the state of Goa with respect to that act. There was actually no study, very limited study rather. And the second gap which I found was there was no evaluation of different laws of the countries with respect to the maintenance and welfare of senior citizens and parents. And there was also no key takeaways from those acts or key learnings for India. Statement of problem. As I said, though the act is the first of its kind, it's the first of its kind to provide for cancellation of an instrument of gift or transfer. In case the transferee fails to maintain the transferor, that is the senior citizen, the act does not provide for nature of applicability, prospective or retrospective. Now the problem has become more apparent. After I took up the study, I also found that there is a judgment of the Karnataka High Court which stated in clear terms that this is a prospective provision and not a retrospective provision. Hypothesis that the act is not serving the interest of parents and senior citizens adequately. Objectives which were framed were to study the historical background of the rights relating to the maintenance and welfare of parents and senior citizens in India, to compare the provisions of the act with similar laws in other jurisdictions, to analyze the provisions of the act for protecting the interest of parents and senior citizens, to examine the legal principles underlying the act and considering how it fits within the broader legal framework related to the maintenance and welfare of parents and senior citizens in India. Fifth, to appraise the role of the Indian judiciary in protecting the interest of senior citizens in India. Sixth, to critically assess the implementation of the Act in Goa, focusing on legal awareness and sensitization among stakeholders. 7. To collect and analyze data on the number of cases filed under the Act over time in the state of Goa. And 8. To collect and analyze the data on the socio-economic status of parents and senior citizens in Goa for examining the relationship between the status and the experiences with the Act and its effectiveness. Research questions: whether provisions are available at international level concerning maintenance and welfare of parents and senior citizens. Are there any legal provisions to provide maintenance and welfare of senior citizens and parents in India? Whether legal framework available presently for the protection of the interest of parents and senior citizens is adequate in India. Then is the remedy, that is the consequence in the failure to maintain a senior citizen, envisaged under section 23 of the Act an adequate remedy under the law? Are the provisions of the Act protecting the interest of parents and senior citizens in the state of Goa? And whether the Maintenance and Welfare of Parents and Senior Citizens Act has been helpful in achieving Sustainable Development Goal number 3, number 10, number 16. I have employed mixed methodology, so doctrinal as well as non-doctrinal. Doctrinal, I have gone through statutes, rules and regulations, precedents, policy documents, etc. Non-doctrinal is by way of collection of primary data through questionnaires, interviews and the Right to Information Act. Now, the entire state of Goa was divided into 2 districts, North Goa and South Goa. Total sample size was 400, divided into different categories as given here in under: general public, 18 to 59 years. So now this act, the MWPSC Act, defines a senior citizen to be anybody above 60 years of age. So I took that category as senior citizens aged 60 and above, 150 respondents. General public from 18 to 59, 120. Advocates around 100. Judges of the judiciary in Goa were 8, which I have taken. Non-governmental organizations 6. Officials of old age homes 4. And deputy collectors, who are the presiding officers in the maintenance tribunal. Goa has 12 talukas. So each taluka has a separate maintenance tribunal. So I have interviewed and taken responses from all 12 talukas maintenance tribunal. Additionally, I have conducted semi-structured interviews with the Honorable Minister for Social Welfare, Government of Goa, the Chief Judicial Magistrate, South Goa, Secretary of the District Legal Services Authority, South Goa, 2 designated senior counsels practicing in the state of Goa, and Shri Jatin Ramaiah. Now, Shri Jatin Ramaiah was a law student in the year 2009, who was the first person in the state of Goa to file a petition to enforce this act in the state of Goa. So the responses are also divided between North Goa and South Goa in that manner. Limitations of my study were that Goa, although a small state, has various topography. There are some talukas which are still not developed. There are some talukas which are exceptionally developed. So now the talukas of Sattari, Bicholi, Pernem, Kankona, Dharbandora and Sange are still developing. And the respondents there were very reluctant to answer my question as. Whereas the talukas of Bardesh, Tiswadi, Salset, Ponda and Mormugua were highly developed, and their people were more open to answering the question as. Advocates. Now, as I said, since Goa is a very small state, an advocate practicing in South Goa also practices in North Goa. So it was difficult for me to divide them into the 2 talukas. But what I did was, I took their predominant practice and their office situation, and then I divided it into North Goa and South Goa. So their responses could be evaluated. Significance. My study, the main significance, what I believe, that it will help in identifying problems at the grassroots level of senior citizens and parents, and maybe to some extent try to solve them. Now, there is an MPWC Act Amendment Bill 2019, which was supposed to be passed in 2019, which till date has not been passed. So what my endeavor would be to modify this bill as well, give fresh suggestions, and may ultimately lead to the long pending bill becoming an act, or amendment act rather. Now, Chapter 1 of my study deals with maintenance and welfare of parents and senior citizens under Hindu society, Muslim society and Roman Catholic society, because this is the historical background which I am dealing about. The Chapter 1 title is Introduction and Historical Background of the Maintenance and Welfare of Parents and Senior Citizens. Now, as far as the Hindu society goes, we all know Matru Deva Bhava, Pitru Deva Bhava. Parents are gods. Hence, we know from the very inception that the Vedas, the Shastras, these have given our parents and senior citizens this pedestal or status of gods. It was, in the olden culture, it was wrong even to think or consider doing something against their wishes. Over time this has changed. But under the Hindu society, this was what the sentiments were. They were considered as embodiments of Brahma, Vishnu, Mahesh as well. Now, the Vedas state that these people, or these sects of people, had profound insights. They had experiences which young people did not have. So these experiences were also considered to have great value. In the Dharma Shastra as well, Yajnavalakya Smriti, it states that son must take care of his elderly parents if they can't take care of themselves. Also, Dayabhaga Law, Chapter 2, Section 2, says the maintenance of family is an indispensable obligation, as Manu positively declares. Under the Muslim society, the children are obligated to provide maintenance to their impoverished parents. But this is not for paternal and maternal grandparents. So if they were in financial need only, then they were to be provided. Otherwise, if they are not in financial need, they are not to be provided. The Holy Quran says, and be humble with them out of mercy and pray. My Lord, be merciful to them both as they raised me up when I was young. Similarly, the Holy Bible states, listen to your father who gave you life, and do not despise your mother when she is old. So, these holy scriptures also have profound impact on our upbringing. Now, as I started by saying, Goa has a different culture, different law as well. Yes, the Indian law is applicable, but as with respect to family law, with respect to succession, we have a separate law altogether. In Goa, the Portuguese era started in the year 1510, which extended to 1961. During this time, the Portuguese extended their laws to the state of Goa. So it was like a UCC, a Uniform Civil Code. We do not have personal laws to govern us. So we have something as a code by itself. There are different codes which I have mentioned, which I'll come to it eventually. But peculiar things which I want to inform is, under this act or codes, there's equal partnership between husband and wife. A husband and wife are moiety shareholders. So if tomorrow I get married tomorrow, that is on tomorrow's date, and I am owner of a property today, tomorrow my property immediately goes half to my wife and vice versa. So these are some peculiar things which are there in the Goan law. Now, under the Portuguese Civil Code of 1967, now this code is a substantive law. Section 11 talks about what is maintenance. It states that maintenance is clothing, shelter, food, etc. And this maintenance is among descendants and ascendants as well. Now, there's another code of Gentile Hindu usages and customs. Now, what is this? So, when the Portuguese came, they realized that there were various usages and customs which were prevalent among Hindus. So, they codified them as well at that relevant time. But those customs and traditions, or code rather, was never followed in the true sense of the term. So, there is nothing with respect to maintenance in that. As regards the Portuguese Civil Procedure Code 1939, this is the procedural code. It talks about how maintenance should be obtained, how you should approach the court, and a very interesting Article 394. We know about mediation. Mediation is creature of, let's statute now, there's a Mediation Act, and Section 89 of CPC says mediation is now. But in 1939 itself, we had something known as a mediation in this code. So the judge would call for a conference of parties, ask them to sit down and solve their issues, and then mediation would be taking place and maintenance quantum would be determined. So this was a very peculiar and a good thing even in the code of 1939. Recently, in 2012, another new act came into play, that is the Goa Succession, Special Notaries and Inventory Proceedings Act 2012. This came into force in 2016. But what is this act? What do we understand by succession, special notaries and inventory? Succession, as we all know, special notaries are not the notaries who certify documents, but these are notaries who are sub-registrars. They are given those taglines. So wills are executed before the special notaries. Also marriages take place before the sub-registrar, civil registrar. And inventories are nothing but division of assets. So as I've said, 50-50. The husband is 50 owner, the wife is 50 owner. Tomorrow if the husband expires, what happens to his 50 then? This 50 has to devolve on to the descendants or the spouse. If there are no descendants, then the court will be approached. The court will decide what the share of each party is, and then that share will be divided. Like how they have probate, we don't have probate in the state of Goa. So we have something known as the Inventory Proceedings Act 2012. This also does not have anything strictly with respect to maintenance, but it does state that wherever there's a forced heir, wherever, let us say, the father has gifted the property or given preference to one particular son, then that person who has been lost out of it, he can claim maintenance through that property. Now, chapter 2 is the global perspectives on the maintenance and welfare of parents and senior citizens. There are various things which I'll try to cover it up faster, but Universal Declaration of Human Rights, the Magna Carta of Human Rights, has, as we know, 30 articles, and the preamble. Article 25 is like the bedrock. It ensures right to an adequate standard of living. So this would also cover a senior citizen, regardless of age. International Covenant on Civil and Political Rights. Now this also ensures personal liberty under Article 9 and guarantees legal equity under Article 26. So these are more or less similar to Article 21 of our Constitution and Article 14 of our Constitution. Also, there's an International Covenant on Economic, Social and Cultural Rights, 1966. Here as well, Article 9 encompasses social insurance, and Article 11 recognizes entitlement of individuals to sufficient standard of living. So these are more or less like our directive principles of state policy. Further, we will talk about now the First World Conference of Aging. This was the first official conference on aging in the world. So there are various recommendations which were laid down by this assembly. Recommendation number 2 stipulated about healthcare. It recommended that healthcare should be catered to, that they should be given preferences, that healthcare should be developed. It should also encompass mental health of an aged senior citizen. 19 spoke about housing for the elderly. So what kind of an housing? Because we know that senior citizens are not mobile, that mobile. They are mobile, but they are not mobile. So mobility, that housing should consider that the mobility issue of senior citizen. Then recommendation number 23 states that crimes or instances of crimes have to be reduced. So authorities have to see that there is an agency so that crimes against senior citizens is reduced. Then recommendation number 25 states that, or recommends rather, that family as a unit should be given preference. It should be seen that family as a unit is allowed to grow. Then recommendation number 28 recommends the integration of aged individuals in government decision processes. So who better than the victim themselves who would give a better proposal for a decision. So tomorrow, if there's a policy decision which is required to be made with respect to, let us say, health insurance of a senior citizen or any other policy, then who better than a senior citizen to have a say? So that is that recommendation. Then recommendation number 34. This is very different. So we know that senior citizens can be institutionalized. Many a times these institutions, old age homes, they are like a prison. I'm sorry to say that word, but that is how it is. I've been to old age homes during this particular experiment, let us call it, and I was very disheartened to see that they were in a very bad state. So these institutions should be more like a home rather than an institution. They should be more like the society, how we expect ourselves to be treated. So these institutions have to be, that recommendation says that the institution has to be more like a family. Then recommendation 36 suggests a minimum source of income. So why is this? Everybody should have a minimum income. So why not a senior citizen? How will they purchase? How will their purchasing power be affected otherwise? So it states that everybody, even a senior citizen, should be having a purchasing power. Now the United Nations Principle for Older Persons laid 5 principles. Principle of independence, that he or the senior citizen should get enough amenities to be independent on his own. Principle of participation, as I said, the same thing earlier. Principle of participation in policy making decisions, etc. Principle of care. So principle of care is health care, mental health care. Principle of self-fulfillment. So it is more like how they would reach their full potential. This would usually be through being able to draw some income. And principle of dignity. Same thing as I've said earlier, if they don't have a dignified life, if the institution itself is not dignified, how will they have a principle of dignity? Second World Assembly continued the First World Assembly's principles, and it further found out, or gave rather, 3 priority directions. The first priority direction was older persons and development. So in terms of this, they should be allowed to be engaged in developmental processes. Now if the panel remembers, it's the same thing as recommendation number 28 and principle of participation. So they are all interconnected. Thereafter, the second priority direction was advancing health and well-being of persons during their old age. So same thing again, principle of care, which we are talking about here, and recommendation number 2, which was there earlier under the old First World Assembly. And third, ensuring enabling and supportive environment. So again, supportive environment, as we were saying, for dignity and again institutionalization. So recommendation number 34. Now there is a Convention on the Rights of Persons with Disabilities 2006. In terms of that, article number 3 states that it advocates dignity and personal autonomy of the individuals. Again, recommendation number 23, principle of independence, that is the interlinkage. And article number 19, right to live autonomously. Again, 36, and this also has a reference to article 21 of our Constitution of India. Open-ended working group of aging. Now, there was open-ended working group on aging which was prevalent from the year 2010 to 2024. Now, it aimed to strengthen human rights protection of older persons. Finally, after its extensive study, it stated, or it rather suggested, that there should be a binding convention or binding law to that effect, but that has not happened till date. Sustainable Development Goals 2030. We know that these are what shapes our studies these days. Every study considers this. So these were started with the principle of leave no one behind. Also, sustainable development would be development without any repercussions to the nature, to the future, etc. So now all nations have to follow the sustainable development goals. It is not, we all know these are all not mandatory, but yes, then it has an effect on how the other countries look at us. There is a Sustainable Development Index also which has been framed, and each country is kept on a ranking. I'm sad to say India is on a very bad ranking there. India's ranking is 99 out of 167. So we are very lower on the ranking. But Sustainable Development Goals which affect our study are goal number 3, 10 and 16. Goal number 3 talks about good health. Again, as I've said, it relates to recommendation number 2, principle of care, second priority direction. So these are all interlinked again. Goal number 10 talks about reducing income inequalities. So again, it's principle of dignity, first priority direction, which is associated again. So, and goal number 16, it talks about peace, stability and effective governance. It tries to reduce forms of violence. So again, principle of care, third priority direction, and recommendation number 23. So again, there's an interlinkage between all these policies. Thereafter, there's an Inter-American Convention on Protecting the Human Rights of Older Persons. Now, this is only between American countries, but what is important to us is Article 7, which guarantees the right to engage in cultural, social and political activities without discrimination of old age. Then we go to United Nations Decade of Healthy Aging. United Nations Decade of Healthy Aging focuses on some areas like as to how we see aged people. So they say that the outlook or our way of seeing old age people has to change. Then also ensure that the communities foster the abilities of older people by creation of a friendly environment. So there should be a friendly environment, etc. Then we proceed to the International Day of Older Persons on the resilience of older persons in a changing world. This was in the year 2022. Now, it was just a day which was celebrated, and it was said that women or senior citizen women should be looked into, and their way of looking at these women should be also changed. Now, learning for India can be seen from going through these countries. I'll be very brief, but there are some learnings which you can have from these countries. Like for example, Sweden is really good at healthcare. So it focuses on recommendation number 2, principle of care, second priority direction, and goal number 3 of sustainable development goals. So because of its good healthcare, it is ranked presently second in the SDG index of 2025 and even now 2026. Norway has allotted per capita budget for senior citizens the most in the entire world. So budget allocation is the most by Norway in the entire world, and hence it is ranked at 7th in SDG index. Denmark has started something known as Senior Citizens Council. If the panel remembers, Senior Citizens Council are those councils which would help in forming governments or drawing policies for the benefit of senior citizens. So it also caters to those recommendations which were there earlier. So So recommendation number 28, principle of participation, etc. Netherlands has the Dutch national care for the elderly persons, and hence it also ranked as 23 in the SDG index. Canada has a very good public pension system. So senior citizens can draw pension very effectively. So because of that, they are ranked 25 in SDG. United States of America has the Elder Justice Act, which has a strict hand for elder abuse. So it ranked 44th in SDG. Australia, it also has an advanced healthcare, and because of the healthcare and because principles of care also, goal number 3 has been followed in SDG, they are at 36th in SDG ranking. Thereafter we go to Switzerland. Now Switzerland has a very robust NGO culture. So they have something known as an NGO named as Alter Ego, which looks after cases of elder abuse and sees to that they are reported and they are taken care of. So because of this, they are ranked at 26th in SDG index. Japan. I am very fascinated with this country because Japan has various things to offer to India. Firstly, because we share the same, more or less the same culture. They also treat their elders with the same respect. Secondly, they were the first, in my study at least, what I found was, they were the first in the year 1963, as long back as 1963, to come with an act for social welfare for the elderly. So this was the first thing which I found from Japan. They also have a Health and Medical Service Act, which is very profound, and have a long-term care insurance system. So the insurance system is very profound and very good. Because of this, they ranked 19th in SDG. Mauritius. Now Mauritius I have added because although it is very low in the ranking, it is 76, still better than India, but 76. But the reason I have added it because it has something which no other country has. That is carers allowance. Now if we have parents or senior citizens at home, we would know what happens if a senior citizen or a parent falls sick. We take care. We take care of them, and during that time we have observed that it has a mental toll as well as physical toll on us. Many a times we look out for professional caregivers, but we don't get them because that as a profession, at least in the state of Goa, is not that profound. So this has carers insurance program. So carers program which says that allowances are to be given to carers separately. So this is a very good thing. Also, like Denmark, it has a senior citizen council which also caters to policy formation for senior citizens. Hence it is ranked 76th in SDG. We go to chapter 3. Now this is the main chapter. Let us call it the main chapter because it deals with the act and the Indian perspective on it. We know Constitution of India, especially the preamble, article 14, 21 and 41 has sufficient safeguards. Yes, it does not talk about senior citizens because this was an alien concept to the constitution framers at that relevant time because it's a new concept now. But it does talk about equality before law, protection, equal protection of law, and no one's personal liberty to be taken out except by due procedure of law, etc. And state to ensure within its economic capacity the right to work, education, public assistance even in old age. The Maintenance and Welfare of Parents Senior Citizens Act 2007 and PWC Act 2007. Now, the highlights of the Act. We'll talk about the highlights of the Act. But before the highlight, I would like to focus as to why this Act. We know we have studied section 125 CRPC, now which is repealed, and 144 of the Bharatiya Nagrik Suraksha Sanhita takes care of it. But why this Act? Why not 125 CRPC? So when CRPC was under process in the 1973, just before 1973, even the Law Commission felt that it was not proper to add such a civil nature dispute rather in a criminal act. But then they did go ahead with it. Thereafter, in 2007 or before 2007, the Standing Committee for the Act, they sat down and they decided that no, there should be an effective mechanism rather than that. So why effective mechanism? What did they feel? They realized that 125 CRPC was a very long process. File it, serve them, lead evidence, very detailed, not a summary procedure, time consuming, etc. They also felt rather that advocates would spoil the entire scenario. So what they said was, let us make an act, the new act, let us make it very expeditious, let us make it very fast. Only one appeal to be provided, nothing more than that. Secondly, advocates to be barred. So what did they do? They introduced section 17 in the act and said no, advocates not to represent them. Secondly, they said, or thirdly rather, they said imprisonment for neglect and abandonment. So 3 months sentence could be imposed here. And main thing which they felt was, they took, or rather they saw that the family structure in India had strength in the earlier times, and maybe because the situations have changed, this is why the problems have arisen. So how we could solve that? Conciliation. So it says that mandatory conciliation should be had. So that's the reason this act came into picture, and it was passed in 2007. Now the highlights rather would be liability to maintain parent senior citizens. Section 5. So who are liable? The children, the grandchildren. Even if parents are, let us say, biological or adopted or step parents, these will be liable. Senior citizen, also the same factors otherwise. Now what if the senior citizen does not have any children? Who will maintain them? Then if they have relatives who will succeed to their estate, they will maintain them. No age limit for the definition of parent. Now this is, as I said when I started, a senior citizen is defined as a person above 60 years of age. But what about a parent? A parent could be even 21 years of age, but then the child will be a minor, so that would have no age, bearing. But let us say the parent got married in the when he was 21 or 22, and by age of 50 is still a parent. He is not a senior citizen as per the act. He gifts. So that also peculiar situation arises. Maximum maintenance amount has been fixed under section 9 subclause 2 to be 10,000 per month. Consequences for non-payment of maintenance are envisaged under section 11.2, that if the maintenance amount is not paid, then the same procedure under CRPC erstwhile and now the BNS would have to be followed. Warrant of attachment, etc. would have to be removed. Speedy remedy. Now this act, as the goal was, is very speedy. Why? Because when the application is filed before the maintenance tribunal, which would be the SDM or any person not below the rank of an SDM, that application has to be decided within a span of 90 days. This 90 days has to be from the date of service of summons, and 30 days additionally could be granted. So entire process has to be done in 120 days. So that's why it's a speedy remedy. Prescribed duty for the state government. So under this, the state government has the duty to operate old age homes and to also publicize the act. Cancellation of transfer, as I have spoken. Section 23 talks about cancellation of transfer. Now this cancellation of transfer, as I have already explained, has to have those conditions. Compulsory conciliation. Conciliation is compulsory. Now critical analysis of the act. Now let us criticize this act. There is absence of uniformity in the process. Now why is there an absence of uniformity, and why do I say that? Because each state would be having a separate rules and regulations. Each state would be having separate authorities not below the rank of SDM to govern the procedure, and because of that there may not be uniformity or standardization in the process. Insufficient maintenance amount. Now, as I've said, 10,000 is the maximum amount. So tomorrow, let us say I am a very good businessman. I earn in millions. After I reach 50 or 60 years of age, I give my business to my son. Now my son does not maintain me. I was acknowledged a lifestyle of 1 lakh or 2 lakh per month. Now I have 10,000. That's the only thing which I can see. That's insufficient maintenance amount. Specific procedural bottlenecks. What bottlenecks and administrative gaps did I see? There's a confusion in the power of district magistrate. Now, who is a district magistrate? District magistrate is the appellate authority. Under section 15 and 16, the district magistrate would be sitting in appeal over the orders of the maintenance tribunal. But under section 22, the district magistrate will also oversee the entire process. So now there is supervisory jurisdiction as well as appellate jurisdiction, which is a total chaos. Inefficient and unqualified official presiding over the maintenance tribunal. Now why do I say inefficient? I say inefficient because in Goa at least, an SDM or even a district magistrate is not supposed to be legally qualified. They do not possess legal degrees, no law graduate. So they only have revenue powers initially, and now suddenly they sit as quasi-judicial authorities to pass orders. So these are unqualified maintenance tribunals. Inefficient and unqualified official presiding as district social welfare officer. Now who is a district social welfare officer? As I said, advocates are barred. You can't represent an advocate cannot represent a senior citizen or a parent. But district social welfare officers can represent them. But they too do not have any legal qualification. So here we stand, unqualified legal person or a layman arguing for the benefit of a person, and an unqualified legal person again deciding something. That's a total chaos again. Now the duty to look after senior citizens is exclusively on family. So what does the directive principles of state policy say? That the state should endeavor. Where is the role of the state here? How will a senior citizen be maintained by the government? It's only by the family. Tomorrow what if he does not have a family? What if he does not have any relative who will succeed to him? So let us say again an example. I am a senior citizen and I have a very good lifestyle initially. Thereafter I have a bad lifestyle, and thereafter I am unable to maintain myself. I have a house, but because I don't have money I can't live in the house. So should I not be entitled by the government for some fixed amount so that I can live in my own settings? Act is silent as regards childless or relativeless parents and senior citizens, as I just said. Restriction on legal representation. As I just said, section 17 says that you cannot represent, an advocate cannot represent in the tribunal. Section 23 does not apply to parents. Apart from it not being retrospective, it does not apply to parents. Now, what would happen is that, as I've stated, the same example, if I am from a sect in India which marries earlier, in Goa that may not be the case, but if I was married when I was 21 years old, and by the age of 50 rather, I have children who have taken over my business, and thereafter I do a gift deed or a transfer deed. I am still not a senior citizen. I am a parent, but now I cannot cancel my deed because section 23 only applies to a senior citizen and not to a parent. Allied laws, Bharatiya Nagrik Suraksha Sanhita, I have already spoken about 144, it's the old 125 CRPC, and Hindu Adoption. Now Hindu Adoption Act does not apply to the state of Goa, as I have said, because we have the UCC. Programs and schemes. Central schemes which are there: integrated program for older persons. Now this program was an old program which was there in 1992. Now it has been revamped and replaced with an integrated program for senior citizens. Basically the NGOs, the local self bodies, the authorities get funding from these programs to do betterment for the senior citizen. National policy on older persons has nothing but is influenced by the United Nations policies. Indira Gandhi National Old Age Pension Scheme. So this is applicable only to those people who are below poverty line. A person below the age of 79 years is entitled for 200 per month, and a person about 79 is entitled 500 per month. Atal Pension Yojana is any person who is not a senior citizen yet, but he can or she can contribute and thereafter draw out pension. So that is also only for non-taxpayers. Goan scheme, Dayanand Social Security Scheme, this was done in the year 2002. In this, vulnerable groups, including the senior citizens, are entitled for 2,000 per month. Deen Dayal Swasthya Seva Yojana is a...
Kindly give a brief introduction of rest of the chapters.
Yes, I'll do it faster. I'm nearly done, madam. I'm sorry if I've taken a lot of time, but I'll finish it faster. So Dayanand Dayal Swasthya Seva Yojana is an insurance scheme in the state of Goa which talks about 2.5 lakhs per family. It's not specifically for senior citizens, and financial assistance to homes for senior citizens. If there is any senior citizen in a home, that is a senior citizen home, then they are entitled for financial assistance for Alzheimer's, etc. Judiciary, I will not talk much, only talk about the ratio decidendi, which are very important. High Court of Punjab and Haryana had to deal with one case. This is very important. If the panel sees Justice Shanti Sarup Diwan, he is the petitioner. What had happened was, he's a Chief Justice of the Punjab and Haryana High Court. He faced atrocities in the hands of his own son, an advocate, a practicing advocate, and hence he filed a petition. In the High Court, the single judge held that no, you cannot come directly to us because this is a civil nature dispute. You go to the civil court. The division bench in LPA holds that no, the Chandigarh Union Territory had failed in not bringing out rules. Hence, this is applicable. He was evicted, the son was evicted from the house finally. So this is an eye-opener to us that not only normal people but people of affluent nature as well face atrocities at home. Then we go to High Court of Madras. I'll just talk about majority things, better things, let us say. Here, M. Venugopal judgment is very important because the High Court stated that these authorities, the tribunal authorities, are not legally competent. It stated that it should be either a practicing advocate or a retired judge who should sit on this chair of a maintenance tribunal. High Court of Delhi, the important judgment here is Kirti versus Renu Anand. Why? Because it stated that under Article 226 and 227, challenge could be made to the decisions of the tribunal. Then High Court of Kerala, the judgment which is landmark is Mrs. Amira.
Is there any judgment of a Supreme Court?
Yes, should I go directly to that? Yes, I'm sorry. So, Supreme Court judgments are Ashwini Kumar, which was landmark judgment of the year 2016, which was finally culminated in 2019, which laid down directives. Now, these directives which were laid down were firstly, when I started my presentation, I said maybe the constitutional makers were not aware of what the situation would be. This was stated in this particular judgment, that it was like this: the rights of elderly persons is one such emerging situation that was perhaps not fully foreseen by a constitution makers. This is where I get it from. Directions which were laid down where all state governments to consider whether the health facilities for senior citizens are perfect, whether there are geriatric wards which are there, whether old age homes are up to the mark. These were the directions which are laid down. The next judgment is S. Vanita. I'll quickly go through it. S. Vanita was nothing but a conflict of law between the Protection of Women and Domestic Violence Act and this act. S. Vanita was ordered to be removed from the house, evicted from the house. But even before, she had filed a complaint to the protection officer saying that I am subjected to domestic violence. The High Court then drew a harmonious construction and interpretation and stated that no, this looks like a counterblast. So that orders were set aside. Thereafter we go to Sudesh Chikara. I may spend a little more than a minute here because this is a landmark judgment. Why is this important? Because Sudesh Chikara was a judgment wherein the maintenance tribunal, the appellate tribunal and the High Court had ordered for eviction. The Supreme Court observed that when was section 23 or when is section 23 applicable? Section 23 is applicable only if I have done a transfer deed on the condition of maintenance and I am not maintained. So here there was no pleadings before any tribunal or any authority that I am not maintained or that it was on the basis of maintenance, that there was an assurance of maintenance. This was never there in any pleadings, neither before Supreme Court. The Supreme Court said that you should have pleaded this fact. I assume, yes, I understand. Love and affection is what a gift deed is run at, but this love and affection can be in the background and you can plead this before the tribunals, which I have not done. So this is an eye-opener for us because when we file a petition, this has to be done. Urmila Dikshit Samtola and Rajeshwar Prasad are wherein evictions were ordered. So I will not go into much into it. Empirical data which I have collected, which I will quickly go through. Now I have examined, as I have taken responses from general public, senior citizens, advocates, judges, NGOs of old age and officials of old age homes and presiding officers, which are deputy collectors. I had asked parents and senior citizens and general public. I had asked the general public as to whether they have parents and senior citizens in the household. 78% said yes. Same question I asked the senior citizens, whether you have children, grandchildren in a household. They said 87% majority said yes. Increase in atrocities, whether they felt there was an increase or not. Senior citizens, the most affected, said no. They said only 13% said yes. Whereas general public said yes, 54%. Judges said 75% said yes. NGOs 100% said yes. Old age homes 75% said yes, and deputy collectors is split in between 50-50. Kinds of atrocities faced. So there were various atrocities which I gave them as an option. Most of them said financial. Some said physical as well. Mode of maintenance. So how are these people maintaining themselves? How are the senior citizens maintaining themselves? NGOs, and old age homes and deputy collector stated it is a Dayanand social security scheme, and everybody else was equally divided. Now I also asked them, what was the reason for making a gift on transfer? Because what I stated was, essential condition is not out of love and affection, but because you have to maintain me. So whether this gift was done specially for maintenance, out of love and affection, threat or fear, or any other purpose. Surprising, senior citizens said 12% under threat or fear. 1% only for maintenance, securing. Love and affection 13, 6% for love and affection, 3% here. Whether they faced issues of maintenance in the household, general public said 2% yes, senior citizens said 3% yes. Awareness. Finally, what is important is awareness about the act. Whether these people were aware. Majority, 80 and 55% of general public and senior citizens are not even aware about the law. Awareness about the power under section 23, 89%, 80% not aware about the law. Cases of maintenance filed. Whether cases are filed, 0%. No cases were filed, according to them. Now, also whether how many cases were filed, 1 to 10, 11 to 20, 21 to 30, 59% advocates said that they filed 1 to 10. 33, NGO said 1 to 10. Old age home 0, deputy collector 67% majority. How many were withdrawn finally? 33% advocates said they were withdrawn, 1 to 10. 33 NGOs, 1 to 10 again withdrawn. Deputy collectors 14% withdrawn.
It is similar all over the India, so you can skip it.
Yes, okay, madam. So, retrospective applicability, which was the main question, whether this provision in section 23 could be retrospective or not. 89% of general public said yes, senior citizen 84 said yes, advocates 63% said yes, judges 87% said yes, NGOs 67% said yes, old age homes 75, and deputy collectors 75%. So all the respondents said it should be retrospective. Socio-economic status, because this was one of my objectives as well as a question. So whether socio-economic status, whether the education, whether the monetary power, does that play a role in person filing cases? General public said yes, senior citizens said yes, advocates said yes, judges said yes, NGOs said yes, only old age homes did not say yes. Deputy collector said also yes. Now, mode of punishment, most of them said that all of the above should be given, that is fine, imprisonment, both, social service, cancellation of gift. Whether it reduces inequalities, whether the act reduces inequalities, many people to a certain extent stated it so, but old age homes stated no. Amendment. Now that we see that retrospective applicability is required, there are some problems with the act. Whether it requires amendment, advocates majority yes, judges majority no. NGOs yes, old age homes yes, deputy collectors, which are the main authorities, full 100%. All 12 of the tribunals stated that yes, it requires an amendment. That itself shows the problem with the act, because if the main authority only says that there is an amendment required, that means that there is an amendment required. I interviewed these people as well, majority of them.
Please show the slide of your conclusion and suggestions.
Suggestions?
Conclusion and suggestions.
Yes. So, conclusion. I have concluded that we have at the very outset stated that it is an increasing population of senior citizens. Atrocities are ever increasing. Majority of the general public and senior citizens are not aware. We have seen that awareness is 0. 32, there are in Goa, there are only 332 maintenance cases filed till date from 2009 till 2025. Only 332 for a population of 16 lakhs, which shows that awareness is negligible. Also, I believe that because of that, my research questions and objectives have been answered. Suggestions. Now, suggestions which I have, I'll quickly go through, madam. So, legal suggestions which I have had is that there's a reintroduction is required of the amendment bill. Amendment, as I've said, of the act is required. Childless senior citizen is required to be amended. Relativeless senior citizen, these words have to be defined. Affidavit of assets and liabilities. The panel must be aware of the judgment of Rajneesh versus Neha, which was passed in maintenance cases, wherein a wife and a husband, when there's a maintenance dispute involved, you have to give an affidavit of assets and liabilities to show what is your standard of living. The same thing has to be done here, according to me. Presiding officers to be made personally liable, because even though there's a time-bound manner, they do not follow that time-bound thing. new cadre. Even the High Court say that you need qualified individuals here. So please get a new cadre of officials. Either you teach them or you bring legally qualified individuals. Maximum limit, as I've said, only 10,000 per month. This has to be increased. Advocates to be allowed. Now, advocates, as I've said, section 17 is there, so advocates have to be allowed to be brought into the purview. Responsibility for implementation of the order. So what happens once the order is passed? Execution, implementation is not there at all. So there also has to be a purview of maintenance officer. State maintenance fund has to be made so that this funds for the entire process is through the state maintenance fund. Need for active involvement of local bodies, the panchayat, etc. has to be brought. Yes. Section 23 of the Act has to be amended to include interim relief provisions to be in retrospective, provisions to be made applicable to parents as well.
Anything else?
That's it, madam. These are general suggestions which are given: healthcare priority, counseling stations, special cancer screening for senior citizens, etc. And the publicity of the Act to be made.
Oh.
Yes.
So, you have given a very good presentation.
Thank you, madam.
Whatever you are presenting, that is little bit different from your thesis. Your presentation is far, far better than your thesis. Okay?
Thank you.
So congratulations to you and to your supervisor for
Thank
this good work.
Thank you, madam.
So now it's my turn to ask
Yes,
question.
madam.
As you know, it's a ritual of your
I understand.
PhD Viva Voce,
Yeah.
right?
Yes, madam.
So you have written a thesis. Your problem profile is only on one section of this act. That is a section 23.
One of the problem profile. Because I still say that the
So
Act
you
itself
have
is not
more
adequate.
than one problem profile?
Yes. So if the panel sees, what is my hypothesis? That the Act itself is inadequate. One.
Wait, I will come to your hypothesis. That is another thing. Because I am just asking you that you have made your problem profile only on one section.
No. If the panel sees my problem profile.
And you are emphasizing on the section 23 of this act only.
Yes, I have focused on it. Yes, no doubt about it, madam, that I have focused more on section 23.
So I just want to know, do you have any idea about problem profile?
Problem profile of the Act.
That's a statement of your problem.
Yes, correct. So the statement of problem, if the panel sees in my thesis as well. So what I feel or what I've written there as well, apart from section 23, is there is no adherence to section 21 as well. Now what is section 21?
That could be the part of your problem profile.
Yes, it is there. What is the problem here? Under the Act, section 21 says that.
That's why I am asking, do you have any idea about the problem profile? What could be included in the problem profile?
Yes, that it is not published. This Act has not does not get its recommendation. So what happens that since state government was to
It
do
would be better that you should go and read a book of a research methodology, so you will find out what's the problem profile. Right now you are not in a position to listen what could be the problem profile, right? And your hypothesis is that you are showing in your hypothesis that government has done nothing. This law is not suitable, or this law is not effective.
is inadequate, madam. It
You
has
have
gone.
not written the word inadequate.
It is inadequate word has been used, madam.
क्या है आपका? Could you show me?
Yes. So, maintenance and welfare of parents and senior citizens is not serving the interest of parents and senior citizens adequately. So, this word adequate is used because there may be a situation where it does to a certain extent, but it is not adequate. That is the hypothesis, madam.
It's okay. Whether your hypothesis is proved or
Yes, it is because majority of the respondents stated that the Act requires a revamp. It requires an amendment. It requires new things to be introduced.
it means that government is doing something.
It is doing something. It is doing something, but not adequately.
In which aspect?
Now,
In an aspect of maintenance or in aspects of welfare?
both. Now, since I just skipped that judgment, but Jatin Ramaiah judgment, which was dealing with section, all these provisions.
Now another question. What are the welfare provision in this act?
Section 21, Section 20, which talks about bringing about old age homes,
Right.
etc. Those
So
and
have you
medical.
written in your thesis that how many old age homes are there and they are qualifying the condition given in this act?
I have examined 6 old age homes and I have talked with them, and they
You visited, na? I'm
Yes.
just asking you, have you written anywhere that you have a 6 old age home here and these 6 old age homes are qualifying the section 21 of this act?
No, madam, I have not written, because there are in Goa, there are countless number of old age homes, and most of them are unregistered. These are the registered ones which I could
That
go
could
to.
be your part of your research.
Okay.
And that is far relevant for your research.
I'm sorry if I have not covered it, madam.
Then another is another welfare scheme is that?
Sorry, madam.
Another welfare scheme in this
So
section of this.
health. So what does the act say? That every hospital which is a government-run hospital or which has funding from government in any manner has to have separate geriatric wards for the hospital. Also special senior citizen lines, etc. All that also has to be seen.
Have you visited that?
Hospitals have not, madam. Hospitals have not. I have not. Yes, old age homes I have done, but hospitals have not done.
If you are doing a research and critically analyzing an act, so you have given only the emphasis on the questionnaire, whatever you have got
Yes.
from that, concluded from that questionnaire, then the judgments, right?
Yes, madam.
But you let the substantive provisions, whether they are following by the government given in the section or not.
Yes, I understand. So although I have tackled one part of welfare, this is the old age homes, in a limited manner.
Don't take it otherwise, but it is just for your
Yeah, I
suggestion that
I
it is
completely
given in the
understand.
act, है ना? Then
Yes.
these are the substantive
Yes.
provisions. So
Yes.
there is substantive section.
Yes, madam.
But you didn't research about that, whether the government is following those substantive sections in the particular area or not.
So I did try to go to
You
the
should
welfare
go
officer.
and you should check and you should
I did
ask.
try. So I did file an RTI. I did try to arrange for a meeting, but they did not allow. Now, as I was saying, what is
And
the
it's one of the shortcomings of
shortcomings?
limitation.
So, madam, if I may just say, at the very beginning, I had talked about an Institute of Public Assistance, if you recollect. That was the Provedoria. So
you
now
can file the RTI.
I did file an RTI there. So they refused to give me information. I tried a first appeal itself,
Then
but
you should write that in your research paper.
yes, I'll do that.
Right, before conclusion, that you tried this, but I didn't get any cooperation from the government
Yes,
side
yes.
or the state agencies.
So in Goa, there are these Institute of Provedoria are those which run the old age institutions.
So why this paper, why this act is known as a paper tiger?
As I've said at the very beginning, it does talk about maintenance, but finally it's lost entirely if it is only 10,000. Secondly, the effect is lost in view of the judgment as well, that these people who are unqualified are passing judgments which finally go to the High Court and are remanded. In Morajka judgment of a Bombay High Court, finally remanded the entire matter because even mandatory conciliation was not done. That's it.
It's okay. Congratulations.
Thank
Now
you,
you
madam.
are a doctor.